Good evening, everybody. Just before we get on to the next part of the look at Judge Hamilton's dissenting opinion, today, congratulations to Jerry Buting. If you'd care to join me in sending a tweet to Jerry, marks 27 years today that he's been at the law firm of Buting, Williams and Stilling. So I've just done a tweet to Jerome, but Jerry, if you'd like to join in, then please do, and do a little tweet to Jerry. As I say, that's 27 years at Buting, Williams and Stilling. In fact, why don't I just write that down so that you're Buting, Williams and Stilling. It is a long time, isn't it? Buting, Williams and Stilling. In case you're wondering what it says behind me, false confessions, police use them, prosecutors, police get them, prosecutors use them. How can you protect yourself? With great difficulty, it would seem, going by the standard of judgment, when, you know, Judge Hamilton at times seems to say the right things, but yeah, he'll be pleased. He'll be pleased. So Judge Hamilton, he says the right things at times, but his actions don't back up some of what he says. Let's have a look at the. Sorry, there was one thing I was going to share with you as well. The this picture. I was trying to find a thumbnail for the video and a backdrop, and this was brilliant, but it wouldn't fit. It's too wide. But worth bearing in mind. This is from the Innocence Project. 25% of overturned wrongful convictions involve a false confession. And of course, once Steve and Brendan are released, those two were convicted based on a false confession, whether directly or not so directly. Anyway, looking at the, let's just once again make sure that everything's working as it should do. I do get a bit paranoid about this at times, as I say, wanting to make sure that things are as they should be. So there's no harm in checking. Yes. Oh, no, not quite what I wanted. Let's come back. Let's make that the whole of the picture, which will make life much easier to see. So here we go. We left off, and we're just going to go through this paragraph which ended with the key, just so that it makes a bit more sense. This is Judge Hamilton talking. What page are we at the moment? We're at page 111. Probably got this part and one more part to go, and then hopefully we should be done with the Judge. Well, no, we won't be done with Judge Hamilton because we've got his majority opinion to look at as well. However, in one telling departure from AEDPA deference, the majority cites a law review article to observe experts on confessions have noted that though courts are reluctant to find that police officers have overwhelmed a child's will by repeatedly admonishing the child to tell the truth, many children will eventually hear tell the truth as tell me what I want to hear. The majority then suggests that Dassey found the truth either by stumbling upon it or by using the information the investigators had fed him, and asserts boldly that it is impossible to read or view Dassey's interrogation and have any confidence that Dassey's confession was the product of his own free will rather than his will being overborne. The majority invites the reader to scrutinize Dassey's confession with this key in hand. I read and see the evidence quite differently. Why, yes, you would, Judge Hamilton, because you're corrupt and you're trying to protect your friends in the state system. Dassey's confession appears to have been the product of a guilty conscience. Coaxed rather gently. I think he uses that line, doesn't he, in the oral arguments. Coaxed rather gently from him with standard, non-coercive investigative techniques. Even assuming, however, that the majority's interpretation is plausible, our job as a federal court reviewing a state conviction under 2254D is not to consult scholarly literature in search of new best practices. That was the classic line, wasn't it, from Kathleen Zellner? It's not to consult scholarly literature in search of new best practices. Well, what the hell are you there for? Oh, my goodness. Oh, jeez. Kathleen Zellner was absolutely right. What on earth? Why do they not want to adopt the new best practices and search for the new best practices when you've got 25% of all false confessions involve wrongful convictions involve a false confession? Let's just read that again. Even assuming, however, that the majority's interpretation is plausible, my job as a federal court who's hell-bent on just maintaining the status quo, reviewing a state conviction, is not to consult scholarly literature in search of new best practices, because that would really disturb the status quo, wouldn't it, Hamilton? Our narrow task is to determine whether the state court decision was based either on unreasonable application of clearly established law as handed down by the Supreme Court, or on an unreasonable view of the facts. Apart from the uncontroversial observation that juvenile confessions should be treated with care, you see, he realizes that, yeah. Direct appeal to Miranda custody decision, the majority cites no Supreme Court authority in support of its interpretive key. B. Deference on critiquing opinions. Early in its opinion, the majority writes that the state appellate court did not identify the correct test at all and did not apply it correctly. According to Hamilton, this criticism is misplaced. The state court correctly recognized that, one, a confession's voluntariness turns on the totality of the circumstances, and two, the analysis involving a balancing of the defendant's personal characteristics against the police pressures used to induce the statements, that standard fits comfortably within the Supreme Court's explanation in Withrow. Now, I'm going to go back up to this note here, because some of these figures don't seem to match, do they? The majority supports the need for special care in juvenile confession cases by citing studies of exonerated defendants showing that false confessions are more common by juveniles and mentally ill or intellectually deficient suspects. False confessions are a real phenomenon, and even one is very troubling. You see, that's good. That's good, Hamilton. That's, this is the kind of sense that we need to hear from a federal judge. Oh, hold on a sec. Yet we should not conclude from these studies of exonerated defendants that there is an epidemic of false confessions. Have you been watching Netflix, Judge Hamilton? Clearly not. That situation has changed dramatically. The more relevant denominator in the fraction is all confessions. That number is not easy to estimate, but we can estimate a conservative lower boundary for it. Bureau of Justice Statistics reports on felony defendants in large urban counties tally violent felony convictions by guilty plea in just the nation's 75 largest counties. The most recent report is Brian A. Reed's U.S. Department of Justice, Bureau of Justice Statistics, Felony Defendants in Large Urban Counties 2009, statistical tables. The majority's statistics report 222 demonstrably false confessions from 1989 to 2016. From the BJS reports, we can estimate that there were more than 1.5 million guilty pleas to violent felonies over that period. So for every one demonstrably false confession over those years, there were more than 6,500 guilty pleas to violent felonies in just those 75 largest counties. But then even then, we know that a lot of people take the plea bargain. They take this nonsense Alford plea. But it just struck me that, he's saying that, even one is troubling. But then, as I said to Ken Kratz, when he pointed out that Drizzen and Leo were cited by Duffin in his opinion, and I said to Kratz, well, okay, so is there literature to suggest that false confessions don't occur? And really, what Hamilton's trying to say here is that, yes, even one is very troubling, but in actual fact, they're so rare that we don't need to worry about that at all. Don't need to worry about it. So courts look to the totality of circumstances to determine whether a confession was voluntary. Those potential circumstances include the crucial element of police coercion, the length of the interrogation, its location, its continuity, the defendant's maturity, education, physical condition, and mental health. They also include the failure of police to advise the defendant of his rights to remain silent and to have counsel present during custodial interrogations. This fact-sensitive balancing test applies whether the subject is a mature adult or an intellectually challenged high school student. It is the totality of the circumstances underlying a juvenile confession rather than the presence or absence of a single circumstance that determines whether or not the confession should be deemed voluntary. The majority's real concern seems to be that the Wisconsin Court of Appeals only paid lip service to the correct standard, but did not apply it seriously. The majority writes that the state appellate court listed Dassey's age, education, and IQ, but it never evaluated those factors to determine whether they affected the voluntariness of Dassey's confession. Likewise, the majority writes that the state court analyzed some of the investigator's interrogation techniques, but it never evaluated or assessed how those techniques affected the voluntariness of Dassey's confession. Elsewhere, the majority complains that the state appellate court addressed the voluntariness of the confession in 2 short paragraphs. The majority also writes that the less a state court says, the less a federal court can ascertain that the state actually applied a totality of the circumstances evaluation. The majority seems to expect longer, more detailed, and perhaps more anguished opinions from the state courts in such cases. Those expectations do not call for habeas relief. Under 2254, federal courts do not judge the length or brevity of opinions issued by state courts with dockets far more crowded than ours. Federal courts have no authority to impose mandatory opinion writing standards on state courts. The caseload shouldered by many state appellate courts are very heavy. Oh dear, what a shame. So in other words, okay. So therefore, they can just wash their hands of everything by just saying, well, we couldn't really give much time to that one because we've got such a heavy caseload. And the opinions issued by these courts must be read with that factor in mind. Footnote omitted. Reversing habeas relief. Federal court erred by finding that the state court overlooked petitioner's federal claim and by then reviewing that claim de novo. Another case, telling state courts when and how to write opinions to accompany their decisions is no way to promote comity. Where the last state court to review a claim reaches a decision and offers reasons, its decisions is entitled to the same deference whether the court states its reasons succinctly in an unpublished order or expounds at length in a landmark opinion. EDPA deference still applies when a state court offers no reasons. Facially, defective reasons or incomplete reasons for its decision. Where a state court provides no explanation, the habeas petitioner's burden still must be met by showing there is no reasonable basis for the state court to deny relief. Under 2254, a habeas court must determine what arguments or theories supported or could have supported the state's court decision, and then it must ask whether it is possible fair-minded jurists could disagree that those arguments or theories are inconsistent with the holding in a prior decision on this court. See also Williams. Although Richter itself concerned a state court order that did not address any of the defendant's claims, we see no reason why the Richter presumption should not also apply when a state court opinion addresses some but not all of the defendant's claims. Okay. Similarly, even where the last state court to render a decision offered a faulty reason for its decision, although we would no longer attach significance to the state court's expressed reasons, we would still apply EDPA deference to the judgment, turning to the remainder of the state record, including explanations offered by lower courts. So some other examples. A state court could write that it rejected a defendant's claim because tarot cards dictated that result, but its decision might nonetheless be a sound one. Oh my goodness. Anything goes, anything goes. And by the reasoning of Richter and Williams, deference likewise applies where a state court gave some reasons for an outcome without necessarily displaying all of its reasoning. Hansen versus Beth. See also Jardine versus Dittman. Oh, same fella as in the top of this one. This court must fill any gaps in the state court's discussion by asking what theories could have supported the state court's conclusion. Since EDPA deference applies when a state court offers no reasons, faulty reasons, or incomplete reasons, such deference must surely be due where, as here, the state court offers a terse explanation for a reasonable result. This is not to suggest that a state court may evade habeas review by merely incanting the correct test, although in this case, totality of the circumstances, the majority is correct in saying that if a court can merely state the generic Supreme Court rule without any analysis, then no federal court could ever find that a decision involved an unreasonable application of clearly established federal law. EDPA review is deferential, but not toothless. Although I'm sure, Hamilton, you would like it to be completely toothless. Federal courts are charged with reviewing state court records to assess the reasonableness of state courts' decisions. We grant relief in a small but non-trivial portion of cases, at least at the appellate level. The issue is not whether the state court might have overlooked something, but whether the bottom line result is beyond any possibility for fair-minded disagreement. Well, Hamilton, it depends what you mean by fair-minded. Fair-minded or corruption-minded? What federal courts may do may not do is infer that a decision was unreasonable based on the lack of explanation. As a reader of judicial opinions, I too would have appreciated more context and development in the opinion of the Wisconsin Court of Appeals. Yeah, again, just occasionally comes out with something coherent. I cannot, however, hold that the use of Dassey's however, hold that use of Dassey's confession was unconstitutional merely because the state court did not say more about all the relevant factors. Well, it's not the fact that they didn't say anything about it, it's the fact that they were never even considered. The overall mix of relevant factors here simply does not dictate a finding that this confession was involuntary. You're kind of on your own, but there, Hamilton, you and your other three judges, you were merely protecting the state of Wisconsin. Showing a lack of the required deference to the state courts, the majority breaks new doctrinal ground in three significant respects: redefining what counts as a false promise of leniency, relying on police bluffs in the interrogation to find the confession was involuntary, and departing from a series of our court's habeas cases denying relief to juveniles who were subjected to much more pressure than Dassey was. Well, as I say, you know my thoughts on this word bluffing. Okay, let's carry on. First, what counts as a false promise of leniency? The majority opinion loses sight of the difference between general assurance of better treatment, which are permitted even when made to juveniles, and factually false promises, which are not. We have long recognized that a false promise of leniency may render a statement involuntary, but that police tactics short of the false promise are usually permissible. In Villalpando, we rejected a claim that a police detective made a false promise of leniency where she offered to go to bat for the defendant and said she would sit down with law enforcement and probation to work this out, and where she also remarked, "We don't have to charge you." Similarly, in the United States versus Rutledge, a police officer asked the defendant whether he would be willing to give a post-arrest statement. The officer advised the defendant that all cooperation is helpful. We noted that one interpretation of the officer's statements is that it promised a net benefit from spilling the beans, and if the officer made such a promise without intending to keep it, the statement was fraudulent. But it was the sort of minor fraud that the cases allow. Far from making the police a fiduciary of the suspect, the law permits the police to pressure and cajole, conceal material facts, and actively mislead, all up to the limits not exceeded in that case. And see also Fair versus Michael C. Police did indeed indicate that a cooperative attitude would be to the 16-year-old's benefit, but their remarks in this regard were far from threatening or coercive. The majority acknowledges that in Dassey's case, the investigators never made the type of explicit and specific promises of leniency that an adult of ordinary intelligence might understand as a promise. That's right. The investigators' statements were comparable to those permitted in Villalpando and Rutledge. The investigators made vague assurances that honest cooperation would make things easier for Dassey if this goes to trial, that the honest person is the one who's going to get a better deal out of everything. Well, yeah, you're right there. It's all about the deal. And the honesty is the only thing that will set you free. One investigator said at the very beginning of the interview before Dassey had confessed to anything that, from what I'm seeing, I'm thinking you're all right, okay? You don't have to worry about things. But the other then cautioned, we can't make any promises, but we'll stand behind you no matter what you did. Well, it was Fassbender and then Uyghur that said that. At no point did the investigators assure Dassey that he would escape prosecution or receive some other specific benefit if he cooperated or confessed. Another case, Sharp versus Rowling. The subject's will was overborne where detective promised she would not go to jail if she admitted to her participation in the crime. Of course, we hear all along that telling the truth to Brendan, he was educated on the spot that telling the truth meant say something different, and to him the truth will set you free. Telling them the stuff that was different, the stuff they wanted to hear, would set him free. No, I think as far as Brendan is concerned, it definitely was a case of to him a promise of being set free. Anyway, Henry versus Kernan. Subject's will was overborne where the officer falsely informed him that what he said can't be used against you right now. The majority insists, however, that whether police have made an impermissible false promise of leniency or of anything else depends on the subjective perception of the suspect, no matter how distorted or inaccurate his perception might be. Thus, to Dassey, with his borderline IQ and suggestible personality, the investigators' vague assurances had, in the majority's view, the same effect as a fraudulent promise. Well, absolutely correct, yeah. The Supreme Court's totality of the circumstances test takes account of the subjective characteristics of the defendant, age, health, education. Yet no Supreme Court case has held that a confession should be deemed involuntary if the subject believed, however improbably or baselessly, that he had been promised a get-out-of-jail-free card. No case requires the reviewing court to disregard what police actually said on a video recording, no less, in favour of what the defendant, with the benefit of time, hindsight, and savvy counsel, says he thought the police said. At a minimum, reasonable jurists could disagree whether the abstract assurances by the investigators here were, in context, false and fraudulent. That alone should defeat any claim for habeas relief. Let's just quickly, as I say, I'll save one more portion for the last part. Probably do that tomorrow. So he's put another note in here. Let's have a look what he put here. In oral argument, we asked Dassey's counsel to identify a case, any case, in which a habeas petitioner was granted relief due to police representations similar to those made here. The counsel cited AM v. Butler, a split panel decision that is readily distinguishable and illustrates how much of a stretch Dassey's claim is. In AM, the subject was just 11 years old. Yeah, that they reckon that's what Brendan's mental age is, yes. And he was not properly Mirandized, yes. He testified at trial that the interviewing officer made him a specific false promise that if he confessed to beating and stabbing to death his elderly neighbor, God and the police would forgive him and he could go home in time for his brother's birthday party. Well, yeah, Dassey thought he was going to go and meet a girl that night. He thought he would be able to hand his project in, but he was mostly concerned with meeting up with the girl that he was hoping to see. Investigators made no such false promise to Dassey. I'm sorry, Hamilton. I think you're completely wrong. And as I say, getting back to the business of him saying that even one false confession is something to avoid, and then trying to suggest that there's been so many people have pled guilty and given, confessed and given, genuine confessions. Again, even that I would have trouble with, not least when we think about the vanishing trial, the pressure that's put on people to take the plea deal. For Brendan's benefit, if he'd have taken the plea deal, he would have gotten apparently 20 years, which would have been even less with good behaviour. He could have been out, who knows? Well, he's been in what, 13 years. He might be getting out sometime soon. I'm sure that's one of the reasons why Kratz was writing to Fallon to get Brendan's sentence readjusted. Anyway, let's leave it there. That's about half an hour's worth. That'll help the any insomniacs later on tonight trying to get to sleep. I'll say we'll save the final part of Judge Hamilton's dissenting opinion. Although he was dissenting because he had lost the vote 2-1 by that action of him dissenting, we then had a judge that agreed with the Judge Fox, and that made all the difference. Anyway, we'll catch you all again soon, and I've got a few people lined up. I think Tracy Keogh. Got Tracy Keogh not this Saturday, next Saturday, and I've got a few more musicians lined up to come and have a chat with me. So anyway, I'll catch you all again soon. Bye for now.